And a big story this hour comes from India, where the Apex Court has upheld the constitutional validity of India's unique identification card, the Aadhaar. Addressing privacy concerns, India's top court added that Section 57 of the Aadhaar Act has now been struck down. And this means that private companies cannot insist on Aadhaar. Not just that, neither can school authorities or examination authorities make Aadhaar mandatory. Importantly, the card is not required to open bank accounts for obtaining a mobile phone number, but Aadhaar remains a must for PAN cards and filing income tax returns. To address security fears, which has been consistently raised by petitioners, the court said that the centre must bring in a robust law for data protection soon. And still, the Supreme Court feels that Aadhaar is safe and secure. Justice Sikri emphasised that there are sufficient safeguards in Aadhaar and that the difference between Aadhaar and other identity proofs is that Aadhaar has a unique identification and cannot be duplicated. Justice Chandrachud, however, held a different view. He agreed with the respondents that security and safeguards have fallen short of standards required to protect privacy and data protection. Justice Sikri also made some interesting points while reading out the verdict. He said that it is better to be unique than to be the best. He added that Aadhaar gives an identity to everyone. And to bring us more details on this news story, now I'm joined in by former Law Minister Mr. Ashwani Kumar, who joins us live on the phone line. Let's quickly go across to Mr. Kumar. Mr. Kumar, a very warm welcome to Wion. Sir, the Supreme Court has upheld the constitutional validity but has struck down parts of the Act when it comes to the Aadhaar verdict. What can the common man make out of this? Please break it down for us.
Well, no one has read the judgments in their entirety, and therefore it will be wrong to comment on the nitty-gritty of it. But the broad picture that emerges from the majority judgment authored by Justice Sikri is that the Aadhaar as an instrument of empowerment is a constitutionally valid initiative. It has, of course, underscored the need for data protection and has advised the government to suitably legislate on the subject. Justice Sikri's judgment does not discount the importance of privacy as a matter of fundamental constitutional importance. But he seems to have come to the conclusion that there were enough safeguards within the present architecture of Aadhaar as improved from time to time, and therefore, on balance, has upheld its implementation. But he has also said that this will not be compulsory for various purposes. Therefore, he has diluted the rigor of Aadhaar somewhat to ease the difficulties being faced by various segments of society. But I would also like to comment on the judgment authored by Justice Chandrachud, which makes some extremely valid points.
Right.
Aadhaar was always in question on the issue of privacy. And Justice Chandrachud says that the privacy architecture falls short. And knowing the reasoning of Justice Chandrachud and knowing the scholarship that goes into his judgments, I think government will be well advised to take his judgment not as a minority judgment, but as a judgment on principle and take further measures to safeguard the privacy concerns of citizens, since privacy has now been unequivocally held as
Absolutely.
part of basic fundamental rights.
Right.
So therefore, this is the most important aspect of the judgment which the government will need to consider in order to dispel misgivings of segments of Indian people.
Right, absolutely. Very rightly said, Mr. Kumar, because, the petitioners constantly were asking, does Aadhaar infringe on our fundamental right to privacy? And that is why Justice Chandrachud also brought in this very, very valid point. He agreed with the respondents that security and safeguards have fallen short of standards required to protect privacy. On that very point, I would also like to rope in our political editor, Mr. Karthikeya Sharma, who also joins us live from the newsroom. He also has a question for you. Karthikeya, please.
Thank you. Thank you so much. Good afternoon, Mr. Kumar. Karthikeya from the newsroom. My question to you is, sir, what happens to the data? Now, certain sections have been struck down, sir. The 57 telecom companies cannot take our data. But anyway, most of the data has been harvested, sir. In your opinion, what happens to the data which is already there in the hands of private companies?
Well, it would appear to me that henceforth they will not be able to commercialize it and they will not be able to use it contrary to the spirit and intendment of the judgment. Of course, what has already gone in the public domain cannot be reclaimed now. But the fact is, its further dissemination will now need to be checked. And that is why the majority judgment recommends the data protection law so that the contours of how the citizens will be able to have their data protected will actually have to be unfolded in the specific law, which Parliament will now have to enact. And already there's a committee, as you know, which has gone into this. But I would again want to emphasize that even the majority judgment on principle does not discount the relevance of the privacy argument. The privacy argument was always the concern, and when I was the Minister of State for Planning,
absolutely,
I had similarly raised the concerns about privacy, and at that point of time, it was not clear whether Aadhaar would become mandatory or not. In choosing to dilute the rigor and application of Aadhaar, making it not compulsory for certain purposes, I think Justice Sikri has implicitly admitted that there are certain issues and difficulties within the Aadhaar architecture, but as is always the case, constitutional adjudication is about balancing of interests. Please don't forget that the nation has spent thousands of crores on this program, and its ultimate objective is a good objective. It seeks to empower marginalized people. It seeks to channel subsidies where they belong, and it seeks to curtail unnecessary expenditure in the delivery of services. So all this having been considered, Justice Sikri has sought to reconcile different constitutional imperatives as best as he could. So I would welcome the majority judgment, but equally and strongly welcome the caveat that Justice Chandrachud has entered in his judgment, which must be taken most seriously by the government.